The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Here.
Carter. Breen. Young.
Here.
Arbit. Devendorf.
Here.
Devendorf.
Here.
Cerniglu.
Here.
Filler.
Yes.
Mueller. Bazat.
Present.
Harris.
Here.
Bagul.
Here.
Madam Chair, you have 10 members present. You do have a quorum. Thank you. And Rep. Cerniglu makes a motion to adopt the March 7 minutes. And we now have Representative Pohutsky in testimony in support of her bill, House Bill 4202. Go ahead and start when you're ready.
Good morning. Thank you, Madam Chair and members of the committee for allowing me to speak to HB 4202. Many members of this committee are likely aware that for much of our history as a result of common law precedents, spousal rape was a legal impossibility. By definition, regardless of the particular facts and circumstances, sex between husband and wife was not cognizable in courts as rape. Consent was implied by the fact of marriage. Thankfully, society's understanding of marriage and consent has evolved over the centuries, and all states now criminalize marital rape. However, as the legislative process, as most of you know, kind of moves in fits and spurts, so many state prohibitions on marital rape do contain statutory exemptions to the general prohibition on marital rape. Michigan is one of those states. So the bill before you this morning would close one such loophole in Michigan law that, to put it in the simplest terms, allows a person to rape their spouse if the spouse has been drugged without their consent. More specifically, one of Michigan's exemptions is mental incapacitation, which is defined in statute as an instance where a person is rendered temporarily incapable of apprising or controlling his or her conduct due to the influence of a narcotic, anesthetic, or other substance administered to that person without his or her consent, or due to any other act committed upon that person without his or her consent. So this is the exemption that my bill proposes to strike. So as you can see, the legislation is very brief. I think it speaks for itself for the most part. It's common sense legislation, and as a state, as a society, we've come a really long way from the days where marital rape was just simply not a legal possibility, but clearly our work isn't done just yet. So I'm grateful for everyone who has put work into this. This is the third time we've introduced this, and as Vice Chair Filler can attest to, it's been a bipartisan effort. Thank you for your work on this in previous sessions. So it's an overdue step, but I'm really grateful that we are moving forward with this. So thank you very much, and I'm happy to take any questions for me. We also have other folks here to testify.
Representative Filler.
Just quickly, yeah, thanks for your work on this. We did have to deal with sort of misinformation, and I think you did a really nice job. We were proud to support last term. And again, just taking one sort of antiquated defense away from a really bad actor, I think is really important in these possible accused rape cases. So thanks for your work, and I will support the bill.
Thank you. And I do just want to clarify as well. I know that when we look at these really old laws, we think that this is something that's on the books but not really used. This actually has been a problem in terms of folks being charged with spousal rape in this state and other states. And it also provides a chilling effect. There are folks who do not even want to attempt to pursue charges because this law is on the books and they don't know if they'll be able to overcome it. So it is antiquated, but it does unfortunately have contemporary implications as well.
Representative Breen has a question on Zoom.
Thank you, Chair Hope. Thank you, Representative Pohutsky, for bringing this forward. You have somewhat answered my question. I'm wondering, and I imagine this would be very difficult to get this information, approximately, if you have any idea, how many cases happen every year? I can't help but think that many people are reluctant to come forward in the first place, and also because of this particular issue, charges aren't even brought. So I'm wondering if you have any idea as to how broad the scope of the problem is?
So I think when we look at this specific set of circumstances, it is helpful to also look in the context of the underreporting that goes on with sexual assault, period. We know that roughly only a third of people who are victims of sexual assault come forward to attempt to press charges. Anecdotally speaking, that number is even lower when it comes to marital rape, just because of the stigma against it and the extra scrutiny that these cases come under. It's difficult to find a statistic for something that isn't happening, right? If charges are not being pressed, it's difficult to get a statistic because you don't keep track of the cases that are not brought forth. But I know the coalition is going to testify as well. Anecdotally, there are cases of people who have declined to pursue charges because of this law, or were not able to press charges. So they can speak more to that. But a firm statistic is harder to come up with just because these crimes are underreported as it is.
Thank you for that clarification. I'm very, very glad that you're bringing this forward. I'm happy to support this bill.
Of course.
Representative Cerniglu.
Thank you. And I believe you mentioned this earlier, but if you could just kind of refresh my memory. You said that this was introduced before in the past, and how far did it go? And if you know, why didn't it complete its journey?
Yeah, so it was introduced in my first term, and we didn't see any movement on it. Last term, we were able to get it all the way through the House. It passed out of the House unanimously. It died in the Senate, and the Senate will do what the Senate will do. So I don't really know why it didn't move. I think it just wasn't, unfortunately, a priority. Mm-hmm.
Any further questions for Representative Pohutsky? Thank you, Representative Pohutsky. We at this time we plan to vote next week. Now I will let you know if anything changes.
Thank you.
Thank you. Now, wishing to speak in support of the bill, we have Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence.
Good morning, distinguished members of the committee. As was just stated, my name is Heath Lowry, and I'm a staff attorney and policy specialist for the Michigan Coalition to End Domestic and Sexual Violence. The coalition is a membership nonprofit that is made of over 70 agencies that serve domestic and sexual violence survivors across the state, serving every county in the state of Michigan. Our members provide wraparound sexual assault, responsive services, forensic exams, shelters, and legal advocacy for survivors in every community. And our mission is to have a world free of domestic and sexual violence. I'm thankful that this bill has been introduced again, and hopefully in this session we can finally make rape truly illegal in the state of Michigan. The Department of Justice has stated that less than a third of all sexual assaults are reported to police and other law enforcement. And in Michigan, the FBI stated that in 2021, roughly 6,400 sexual assaults were reported. So you can extrapolate that to be an appalling number of sexual assaults in this state. And further, just an impact on the survivors, that can cost them in a lifetime $125,000. So you take those numbers and look at the cost on Michiganders across this state. It is quite jaw-dropping. I and other coalition attorneys serve survivors in courts across this state. Large urban communities, small rural communities. I serve in tribal communities as well, and we see how an unresponsive system harms survivors. And this is another way that the system can harm survivors. Survivors are being turned away simply because they happen to be married to their perpetrator. And that is a monstrous distinction to make. A sexual assault that happens within the sanctity of marriage should be at least treated as equally as one that happens outside marriage. So we are asking you to support this bill, and hopefully we can move it all the way through this time. Thank you.
Thank you. Do we have any questions for Mr. Lowry? Seeing no questions, thank you for your testimony. And now we have some cards to read in here. Supporting the bill, not wishing to speak, Aaron Van Langeveld from the Michigan Department of Attorney General. Supporting the bill, not wishing to speak, Susie Sherman Hall from State Public Affairs Committee of the Michigan Junior League. Neutral and not wishing to speak is Noah Smith of the Criminal Defense Attorneys of Michigan. Supporting the bill, not wishing to speak, Megan Reynolds from the Michigan Poverty Law Program. Supporting the bill, not wishing to speak, Brandon Lanyon of PAM. Supporting the bill, not wishing to speak, representing herself, Sarah Morley LaCroix. Supporting the bill, not wishing to speak, Marissa Kovach from the ACLU of Michigan. And now we will turn to a presentation from Aidan Cotter and Madeline Bailey with the Vera Institute of Justice.
Good morning. Thank you, Madam Chair and members of the committee for making time to hear from us today. My name is Madeline Bailey and this is Aidan Cotter. We're here representing the Vera Institute of Justice and are grateful for the time you've made for us today to discuss the pretrial reform policies that are currently being considered in the legislature. So the Vera Institute of Justice is a 60-year-old research and policy organization that works on criminal justice reforms that are grounded in evidence, data, and research. Our organization has worked on pretrial reforms in states like Tennessee, Kentucky, Texas, New Mexico, New Jersey, and more. And our broad experience has been that well-crafted and measured pretrial policies can both protect public safety and increase fairness and justice in the system at the same time. It is our strong belief that the policies that are being considered this session will accomplish both of those goals as they are measured and grounded in stakeholder conversations. Our organization was invited into Michigan to help facilitate a bipartisan coalition made up of Michigan organizations that are working to help get these policies across the finish line. So I'd like to start by just describing the years of work that have gone into these policies. Many of you know that this work sort of began with the governor's establishment of a task force on jail and pretrial incarceration in 2019. This task force was established to consider data from across the state and to create recommendations for consideration by the legislature to address their findings. So for over a year, the task force met, held regular public meetings, subcommittee work groups, and stakeholder roundtables. They examined 10 years of arrest data from over 600 law enforcement agencies, 10 years of court data from 200 district and circuit courts, and 3 years of jail admission data from 20 different county jails across the state. And based on all of that, they came up with 18 recommendations. Most of those recommendations, as many of you know and have worked on, were addressed in 2020. But the pretrial reform portions of the recommendations were sort of saved for later in the interest of time and were introduced in late 2021. So leading up to introduction of those bills and also since, there have been really extensive stakeholder conversations and changes made for stakeholders to ensure that these policies remain measured and are actually workable for the state of Michigan. So those stakeholder conversations were led by Representative Andrew Fink last session, worked with the prosecutors and PAM, worked with judges from both judges associations, domestic violence organizations in Michigan, and also extensively with Representative Mike Mueller in order to get sort of the law enforcement perspective. So we've made many changes to sort of honor those stakeholders and are continuing to work with them to ensure that these policies match up with their experience day to day. So also, as many of you are well aware, throughout last year, we worked with almost every member of the House that we could get time with. It was led by conversations with Republicans such as Representative Johnson, Representative Mearman, Representative Van Workum, Representative Fink, and Representative Brand.
Good morning. So Madeline discussed with you a little bit where we've been with these bills, and I just want to talk about where we currently are. So even though obviously we know the balance of power in Michigan has shifted, the bill package itself remains nearly identical to where we left off last session. And that's for a couple of important reasons. One, as Madeline mentioned, we've had numerous discussions with various stakeholders. And our coalition discussed this and felt like it was very important to maintain the integrity of those conversations that we've had with stakeholders. And that was important to us for a couple of reasons. One, so that the stakeholders would understand that we come to these negotiations in good faith. And also, we fundamentally believe the best policy is achieved when various actors in the system are at the table. We also didn't change the bill drastically when the power shifted, because fundamentally, this is not a partisan issue. Pretrial reform isn't a Democrat issue. It isn't a Republican issue. It is good policy. And I imagine that most, if not everybody in this room and on Zoom, would agree with me that presumed innocent people who are not a risk to public safety, should not be in jail simply because they don't have a few $100s to post bail. These bills have wide bipartisan support, and polling demonstrates this. We've done polling that shows Republicans, Democrats, independents, crime victims, they support these policies. And as we speak with folks, here's just a few of the reasons that people support these policies. These policies are supported by people who believe in the Constitution, people who believe in the presumption of innocence, people who believe in due process. The bills are wildly supported by people of faith. We've spoke to so many people that support this issue because they come from a position of faith. And we also have wide support from the business community. And that's because fundamentally they see this as a workforce issue. They understand that if their employee is arrested and can't afford a few $100s in bail, they sit in jail and they do not come to work and the business suffers. And finally, this is not a partisan issue because just like Madeline told you, that these policies are founded in Michigan data, and it's narrowly tailored to the realities of Michigan. And I think we have this enormous opportunity right now to learn from the mistakes and what other states have done right that have already attempted this issue, and really situate Michigan as a national leader in how to come together and do this issue right. I want to just very briefly talk about the bills. I'm not going to go really into depth here. I know we've spoken with a lot of you in your offices, and we would like to continue to do so and to go through these policies line by line if you're interested, because we really believe in these policies. But just to give you kind of a high-level view, at the end of the day, when you go through these policies, what you will see is that they increase fairness while not compromising public safety. So our main bill, and the one that you probably hear the most about, would seek to put some sort of limits on the use of money bail. And the reason for that is what the data shows us is roughly half of all people cannot afford a $400 emergency expense. And so the way these bills target that is saying for those low-level offenses that by their very nature are not a public safety risk. So we're not talking assaultive offenses, we're not talking domestic violence, we're not talking sexual offenses, we're not even talking DUI offenses, offenses that do not implicate public safety. For those offenses and those offenses alone, judges would not be able to set money bail as a condition of being released from jail, but they would be able to set conditions meant to ensure that the person would come back to court, ensure public safety. And we talk about public safety so much because we firmly believe that these policies will actually not only protect, but enhance public safety. And that's because I don't know if any of y'all had the opportunity to observe arraignments in courts. I was a defense attorney for about a decade, and I can tell you they go very, very quickly. I'm talking minutes. And that really is not good for public safety, but it is that way because there's so few judicial resources that it's almost like rubber stamping cases. By taking the low-level, nonviolent offenses off the table, we're actually freeing up judicial resources for judges to spend time for those cases on the margin where maybe there is a public safety concern. I also say that these bills enhance public safety because, again, Vera comes at these issues from research and data, and what the overwhelming research shows, when you detain people pre-trial, they're actually more likely to get rearrested in the future, which of course is not good for public safety. And I think if we step back from that for a second, that's probably intuitive to all of us. We know what happens if you are detained pre-trial in jail. First off, you lose your job. And because you've lost your job, now maybe you lose your housing, your car. Maybe because you're in jail, nobody's taking care of your children, and now the state has taken them. And this is very destabilizing on a person's life, which then makes them more likely to get rearrested in the future. We have another bill that comes from the findings of the task force that would look to enhance due process a little bit. Like I said, these hearings are very, very, very quick. This would give the ability, if somebody remains in jail for 48 hours, they can request another hearing in front of a judge to present more evidence to make sure the judge got that decision right, because we are talking about somebody's liberty. Another finding from the task force, speedy trial. What the task force found is that there were people literally in jail for years awaiting their day in court. Michigan does not currently have a statutory speedy trial right. We would seek to put that at 18 months, and there would be numerous exceptions, such as delays attributable to the defendant, if there are reasons why victims can't make it to the trial. So there are a lot of exceptions in there, but it looks to put a time limit on it. There is an interim bond provision, and currently, under current law enforcement is able to release people accused of a misdemeanor if they're not a public safety risk, if they're not intoxicated. This would essentially make it so that for those low-level misdemeanors, so not even serious misdemeanors, but the lower-level misdemeanors, to still release that person if they find they're not a risk to public safety, but just release them without the requirement of paying money bail first. There's also a child support bill that would essentially change the way bail is set in child support cases. And then the only really difference from last session and this session is a bill that would seek to establish a statewide pretrial services and supervision. What that really does is give judges another option so that they can refer them to pretrial services to do things like send court date reminders, which have been proven to increase how often people make it to court, to supervise if necessary, and also to look to see, can we address some of the root causes of why people are entangled in the system to begin with? Because again, we know overwhelmingly for these low-level offenses that it's often issues of poverty, substance abuse, mental health, and they would try to connect to services to make sure we look at what are the root causes to begin with. So that's what we have prepared, and we're happy to answer any questions.
Thank you. I have a question regarding the public safety argument that using cash bail only in very serious cases enhances public safety. Do you have data from other states to support that?
Yeah, we have numerous data that we can provide. Essentially, the largest study that I'm citing is actually done over a 10-year period with a sample size of 1.5 million cases. And what they found was if you detain somebody pre-trial, especially on lower level offenses for 24 hours or more, that undermines public safety because that person is then more likely to get rearrested.
And that study's out of Kentucky, Madam Chair.
Okay. We have Rep. Filler.
Thank you so much. Really basically, if you run bail reform like they did in New York and California, where essentially they said no bail for low-level misdemeanors, you essentially telegraph to the individual who may be breaking the law that there aren't going to be consequences. So essentially, in New York, it turned into a revolving door, same in California. And I remember, I believe it's Rep. Young who said this last year, which is the streets talk or criminals talk. And so I know that if I want to run an organized retail fraud ring, I can go to California and sort of get 40 people to bum rush a store, run through the door. They're all going to get charged with low-level misdemeanors, which judges can't bail there. And so they know the consequences are very low, and then they can run back out. So if you tie a judge's hands for low-level misdemeanors, even though the judge says this individual is maybe part of a ring or this is their third one, their third misdemeanor, I really think you're going to turn Michigan into sort of a smash and grab capital, and that is what we've provided or avoided so far. You know, or people know in Michigan that there may be bail offered or there may be a consequence when you break the law, a lower level misdemeanor. So I'm not sure how tying a judge's hands for certain low-level misdemeanors is going to lead to more public safety.
Yeah,
That's a question. Sorry.
Yeah, no, thank you for the question. I see the question in there. So first, as to the issue of consequences and accountability, I think it's important to remember we're talking pretrial. So we are talking when people are presumed innocent and bail is not supposed to be a consequence. It's supposed to make sure they come for their day in court. Additionally, you cite New York and California. These policies are very, very different. They deal just with lower level offenses. And additionally, again, based on...
You had an individual in New York. He's coming back, it was like 50 or 60 times, some low level, some high level too. So, I mean, I know you're trying to avoid the very assaultive felonies, but in New York and California, it was low level too.
Yeah, and just the only other thing I was going to add to that is this is why it's so important that we've had all these conversations with stakeholders. And we've had numerous conversations actually with your colleague Mike Mueller, and he raised this issue. And that was one of the changes we made to the bill, is to address that exact issue that you are concerned about. And so for that example, if somebody does a low-level shoplift, yes, the first time the judge will not be able to set cash bail. However, if they are rearrested and come through the system again, everything is back on the table for the judge, including cash bail.
And I think, Representative, the only other thing that I would add is that for the majority of these offenses, under current practice, people are able to still get out pretrial if they're able to put up that $200. And so I think what we're trying to address with these policies is that whether or not somebody can afford that $200 or $300 isn't actually a public safety determination.
Representative Breen.
Thank you, Madam Chair. I'm curious as to where the judges are at on all of this, because you indicate here that a speedy trial is necessary, yet their dockets are so overwhelmed, and we've had some wonderful progress with problem-solving courts, which lends to a lot of the things that you are trying to do with the pretrial incarceration reform. What time frame are you talking about? Like, what constitutes a speedy trial? What do we have in place to make sure that those time frames can happen? And again, with the expansion of treatment courts, which takes up a lot of time, that doesn't allow for a lot of speediness with other issues. So can you give a little bit of background on that, please?
Yeah, thank you so much, Representative. So the time frame that's proposed by the speedy trial bill is 18 months. So requiring from the time of arrest or citation that somebody be brought to trial within that 18 months with a whole list of exceptions. So if that delay beyond 18 months is attributable to the defendant at all, that excuses the time frame. I think a good, this is a good example of the work that the task force did to make sure that this would be workable for Michigan. Other states are 6 months. Texas was considering a year. So I think 18 months is tailored to address a relatively small number of cases of people sort of languishing in jail for sometimes 3 years, and to really stop that harm from happening. And we've worked with the judges quite a bit and continue to work with them to make sure that these policies will be workable for them.
So they think that 18 months is a feasible, I mean, I would hope so, because you shouldn't be sitting in jail for 18 months to prove your innocence or have your guilt proven. And my follow-up to that is, if judges do set monetary bail, or if they don't, what exactly needs to be put on the record for that? in order to make sure that this withstands any additional scrutiny?
Yeah, thank you for those questions. And I just wanted to add one thing to Representative Breen's question is just because I agree problem-solving courts, just a huge benefit. Just the way that would work in practice, you know, I had many, many clients who were in those courts. Essentially, that goes to a delay attributable to the defendant. So essentially, they just ask the person to waive time, so that those wouldn't really run up against the 18-month clock. And then, thank you for your question about judges. That is a big part. I was trying to stay very high level with the bills, but one of the details with it is that judges would have to state their reasoning on the record, one way or the other. If they're releasing somebody without bail, they would need to say why. And if they're detaining somebody on high bail, they would need to say why. And a big part of that is understanding that judicial actors should be accountable to the public. In this way, if something happens, we can look back and say, okay, what was your decision making? So they would be required to put that on the record.
Representative Young.
Thank you, Madam Chair. Thank you, too, for being here. Appreciate the work that you're doing, continue to do. I just have a couple of questions. It's important for me, and particularly for those who may be listening and watching, that you all would help us understand what it actually means to be not a risk to public safety, and give us an example of these low-level offenses so that we're all clear about what it is you're talking about.
Yes, thank you. So the public safety was really at the forefront of crafting these policies, as you know. And so there are exceptions in there. So anything assaultive, anything of a sexual nature, anything DUI, anything that really like kind of common sense will tell us there could potentially be a public safety risk here based on the charge. And so the type of offenses that this would target is going to be your low-level shoplift. But again, to Rep. Filler's concern, not if you come back a second time, right? So your first time coming through with that. A minor drug possession, driving offenses, but not DUI type of offenses. So driving on a suspended license, like those type of offenses would be what we're looking to target.
Thank you for that, because I think about my home community of Detroit and how we're dealing with high insurance rates and how we know that people, you know, they have terminology, driving dirty. In the city of Detroit, they'll say, officers say, I'll ask for a license, and somebody will give them their state ID because they haven't had a license in a while because they couldn't afford it, but these are people who are trying to go to work, they're trying to take care of their family. I mean, otherwise, really law-abiding folks that's just trying to make it, but because of systemic things that have been put up barriers in their lives, they're forced to have to do some things that other people don't have to do. And so that's what I want to be real clear about when we look at this legislation, how we're trying to level the playing field. That's how I look at it. If all things are equal between you and me, and you have $250 to go home, and I don't, I get locked up. And then you look at the reasons why I don't have $250. It wasn't my fault that I couldn't get a good education. You know, it's a whole long list when we start dealing with systems that work against certain groups of people. So if there's a comment that you want to make today, like you're about to say something, Aiden.
I was, and then I think you kind of covered it, Rep. Young. But I think I was going to say exactly to the point of if we're taking this type of offense where really that person is probably in that situation because they don't have the money to get their insurance right or their license right. And now if they are arrested and are forced to pay $500 to $1,000, maybe they do somehow scrape together that money, but now we've just created the cycle and made it even worse because now they have to pay that money first before getting to address the issue of whether it's their license or their insurance. But absolutely.
I just want to thank you, Representative Young, for your leadership on this issue.
We have a question from Representative Bazat.
Thank you, Madam Chair. Thank you for your testimony and your work on this issue. As a county sheriff, I'm definitely interested in keeping people out of jail, but I'm concerned about the one question was asked about the judge's support as well as the prosecutor's support. I'd like you to comment on that if you could. And also, the judge can put these certain people that can't afford it, indigent people, where they can put them on a tether. There's so many things. I'm really in a position where I don't want to take discretion away from a judge or a prosecutor. So could you comment on that? Thank you.
Thank you so much, Representative Bazat. To speak briefly to the concern about judicial resources, I think the intention of these bills is really to allow judges more time to deal with cases that do implicate public safety by taking the low-level charges off of their docket. They'll still get to consider them and, just like you said, set conditions, but in order to really focus on the cases that do implicate public safety, taking those off of the docket. You asked about the prosecutor's support. We've spent a lot of time over the last year with DJ Hilson and now Brandon Lanyon from PAM, and really gone line by line, making sure that they're able to sort of address everything. I don't want to speak for them, and they're not here today, but I will say that we've reached a really good place on the main bill, and I think it's fair to say at this point that they are supportive, or at least neutral, on the main bill. We still are going through the rest of the bills with them, and again, I don't want to speak for them. Their position may change for that main bill too, but.
Representative Cerniglu.
Thank you. And again, forgive me if any of this is a repeat. I know you've covered a lot already, so it might be a repeat. But I have a few questions, just kind of short questions. First, just maybe if you could talk about how, it might be determined if someone's getting cash bail versus a personal recognizance bond, and how that might be determined if it's just a judicial discretionary type question, or if we see a lot of discrepancy from judge to judge or court to court. And I'll let you answer that, and then if it's okay to go to the next.
Great, thank you. Your last point there was really important. Because I think currently that's a big part of the reason that the task force wanted these changes, was that currently it does differ wildly based on where you are in Michigan, and understanding that people should be treated similarly despite of where they may live. And then I think your other question was about how they determine what to set as far as cash bail, is that right?
Right, just giving cash bail versus a personal recognizance bond.
Yeah, so I mean, that's part of the reason for these policies. Right now, a lot of why judges come to the decision they come to, we don't know, because they're not articulating their reasoning on the record. Of course, sometimes a concern is whether implicit biases can come in terms of bail setting practices. But under this package here, for the low-level offenses that are not a public safety risk, money bail wouldn't be considered. But for the other offenses, judges would be considering whether there's a public safety reason to set money bail, and essentially outlining their reasonings for that.
Thank you. And do you have any, you probably don't have any statistics, so this might be a more subjective question, but any insight on who actually pays that bond, or that bail, whether it's actually the person or it's really their family, and how effective that even is?
So first of all, two different answers to that. One, often it is through bondsmen. And for offenses like these that we're talking about taking money bail off the table, because those are low-level offenses, overwhelmingly these are going to be lower bonds. And often if somebody goes through a bondsman, it's 10%. So we're talking about literally hundreds of dollars here, which is why we say that whether you can pay $400 or you can't, that really shouldn't make a determination of whether there's a public safety risk. And then as to your other question, yes, I can tell you overwhelmingly what the data shows us is that it's often women in poor communities, and often communities of color, that are overwhelmingly burdened with paying bail. And of course, when you're talking about communities where money is already tight, resources are already tight, you're taking money away from the community that could be put to better uses.
Thank you. And just one other short question. I know in the past some counties have issues with jail overcrowding. I don't currently know how much of a problem that is, but would something like this perhaps help some of those issues?
Yes, exactly, Representative. I believe these policies, while we might not be able to show an exact projection at this moment, we can try and get you some information on that. It would keep those low-level offenders out of county jails.
Representative Harris.
Thank you, Madam Chair, and thank you guys for presenting. It's we had some good conversation before, and I do appreciate that, and I appreciate the time that you're taking digging into these issues. But one thing, this is more of a comment. So after spending 26 years in law enforcement, I've seen a lot of exceptions to some of the things that you're talking about. And, we have to remember that sometimes these low-level crimes actually result in violent behavior. So, for example, we made national news at my department on a low-level retail fraud that happened, and it resulted in the death of a loss prevention officer during an apprehension. And it was quite graphic, and it was actually one of the things that led Michigan loss prevention officers to a hands-off policy. But we've seen this multiple times where loss prevention officers have been assaulted on just really simple, low-level retail fraud crimes. So I really hesitate sometimes at just letting people back out because, as I'm sure you've heard before, and I think I may have mentioned in our office, it seems like we chase the same people around all the time repeatedly. And I know you addressed that a little bit with Representative Mueller. So I appreciate that, but I still have concerns on the issue.
Yeah, thank you. I think the only thing I would mention, and of course, circumstances like that happen that are tragic. I don't see that this bill would really change that much, right? Because under current law, that person who was arrested and bail was set, we're talking about probably essentially a few $100s. And I think our fundamental position is whether or not you have $3 to your name does not dictate whether you are more or less of a public safety risk.
Thank you, Representative Harris, and we look forward to working with you more on these policies to make sure they're workable.
Representative Arbit has a question on Zoom.
Thank you, Madam Chair. And thank you so much for presenting. I'm very grateful for your work on this. And, I know that, really what we're talking about is just replacing, the variable in terms of pretrial detention. We're talking about, assessing the risk that someone is a danger to the public instead of, how much money is in their wallet. And I really want to dig into, if you can, what exactly the variables within that determination are and what sort of tools can be brought to bear in terms of, when a judge is making that assessment. And also, if you could, sort of the role of prosecuting attorneys and APAs in that when, folks are going to arraignments. And, I worked at the Oakland County Prosecutor's Office, and I know one of the issues was, getting APAs at arraignments because, dockets are such that and caseloads are such that that sometimes is very difficult, especially even a county like Oakland, which is more well resourced than others and has one of the larger offices. Then you've got places that have much higher caseload. So it's just I'm trying to understand the way in terms of implementing this. Obviously it probably will have to come with additional resources as well. But, I guess then two questions, one is about what does the, public safety risk assessment look like and what tools can be brought to bear. And then the second is about, personnel, staffing, resources. Thank you so much.
Thank you so much, Representative Arbit. To your first question, the language of our main bill really asks judges to look at two risk factors. One is the risk to another person or the community at large if the person were to be released pretrial. And the second is the risk of their non-appearance in court or their willful flight from prosecution. And so it's really sort of acknowledging that judges do have limited time and do have a hard job. And it's definitely allowing judges to look at police reports, anything on the papers that would get to their risk determination and allowing them to rely on that. We really acknowledge the limitations that prosecutors in Michigan currently have. And the point of this bill, we've really tried to sort of tailor it to make sure that it wouldn't put any additional strain on prosecutors as it comes to our main bill that you're asking about.
And I think just the one thing I would add, because this is a perfect example, because I think a lot of y'all asked the good question about where do prosecutors stand on this, and again, we won't speak for anybody, but I think their concerns, for instance, with the due process bill is not any sort of fundamental concern about whether people deserve due process, but more an issue of funding and staffing. So I think that is also something we would like to look at in terms of implementation, is making sure everybody, every stakeholder in the system is funded the way they need to be to do their job.
Thank you.
Oh, sorry. Are you good, Rep. Arbit?
Yes, thank you.
Thank you. Representative Young.
Thank you. So I'm thinking about my colleague down there that shared the horrible experience, right? And so there are just as many horrible experiences on the other side when we think about the mom who's trying to get her kids to school, but the tail light is broken and she gets pulled over and she didn't have a good license, and now they want to arrest her with the kids in the car, being traumatized, or waiting for somebody to come pick them up, while they see their mom who might have been guilty of stealing some food to feed her kids because of all these things that put her into poverty that, you know, we can't solve with this legislation. But we gotta put that human face on it. My colleague put the human face on it when things go really wrong, but there is still another human face of people who can't simply make that bail amount, can't pay that bond, who end up locked up, and then this ripple effect. You guys touched on it a little bit about the potential of now you got CPS in your business because you're locked up and there's nobody to take care of your children. Now you're looking at not being able to make rent because you can't get to work. Now your employer is missing you. I mean, it's this whole big ripple effect. And I just want to be clear that I don't believe this is soft on crime legislation. I believe this is social justice legislation. And I want you guys to just touch on just a little bit about the statistics that you have in terms of people who actually show up for their court date. I know we've talked about this before. You guys have the data that shows paying the bail doesn't really guarantee you're going to show up. And so if that's the case, then why are we mandating it for these folks with these lower level offenses that, end up in these situations?
Thank you so much for that question, Representative. Just to sort of address the last part of what you said, and then I'll pass it to my colleague. You're exactly right that sort of when somebody uses a bondsman to put up that amount of money, which the grand majority of people do, the original purpose of bail was sort of saying that if you pay money and you show up to court, you have an incentive to get it back. If you go through a bondsman, you won't get that money back even if you do show up. And so that sort of removes that sort of original purpose of having that money bail in place. So it's really just extracting that amount of money. And again, when we're talking about these low-level offenses, that's putting those people at risk of having their kids taken away, a likelihood that they will lose employment for not showing up to work as scheduled, and another, many other ripple effective consequences.
I think the only thing I would add is just this is why we're so thankful that you guys had us here today, because I think sometimes on this issue it is an uphill battle to combat misinformation, and there's a reason why even crime victims back these policies. These are common sense policies, and I think sometimes there's a perception issue. Any loss of life is tragic. But I think we have to be careful about allowing outliers to dictate policy. And the reason I say we have a perception issue is, Rep. Young, your example doesn't make front page news, even though overwhelmingly that is the experience of people every day.
Thank you very much for your presentation today, and I'm sure we will see you again in the future.
Thank you so
Thank
much.
you all very much.
Representative Breen moves to excuse absent members. And there being no further business before the committee will stand adjourned.